according to the Open Public Meetings Law, this regular meeting of the Planning Board of the Township of Franklin has been properly noticed. Can everybody please stand for the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right.
Councilman Chase.
Here.
Mr. Coble. Mr. LaCourte.
Here.
Ms. McIver.
Here.
Mr. Mettler.
Here.
Mr. Pettit.
Here.
Mr. Stevens.
Here.
Mr. Thomas.
Here.
Mr. Alderman. I know you're here. I saw you. Mr. Onyaka.
Here.
Chairman Orsini.
Here. Okay, so we don't have any hearings tonight, so we'll just hopefully be able to rapidly move through this. So, first item is the minutes from our last regular meeting of October 17th, 2012. Are there any comments, corrections, typos, etc.?
If not, I move the minutes be approved.
Councilman Chase.
Yes.
Mr. LaCourte.
Yes.
Mr. McIver.
Here, yes.
Mettler.
Yes.
Mr. Pettit.
Yes.
Mr. Stevens.
Yes.
Mr. Thomas.
Yes.
Mr. Alderman. Mr. Onyaka.
Yes.
Chairman Orsini.
Yes. Second matter, one resolution is docket PLN 11-00015, Genesis.
I move the resolution before the project's completed.
Second.
Councilman Chase.
Yes.
Mr. LaCourte.
Yes.
Ms. McIver.
Yes.
Mr. Mettler.
Yes.
Mr. Pettit.
Yes.
Mr. Thomas.
Yes.
Mr. Alderman.
Yes.
Mr. Onyaka.
Yes.
Chairman Orsini.
Yes. Voucher for November in the amount of $833 for Mark Murphy, our planning board attorney.
Move to approve.
Second.
We can just do this by acclamation? Okay, all in favor?
Aye.
Opposed? Abstained? Motion carries. Okay, so discussion items. Trap Rock and Lakeside.
Yeah, but both are the ordinances verbatim as you recommended them and gave them the Township Council. This is just a formal referral back, so you can formally say they are consistent with the master plan.
Okay, and in case anybody doesn't remember, the Trap Rock was for rezoning of various parcels in accordance with the current and anticipated land use into CP or the mining M3. The Lakeside was obviously for conformance with what is going to be built there, which was approved by the zoning board, which is the R20 density from R40. So we'll just take them one at a time.
Excuse me, before we do that, I just have one question. Does the council send it back to us with any kind of comment, or they just?
No,
automatically
it's
send it back?
it's a referral that's required by law.
Yeah, but do they look at it and say, we don't like this, or we don't like this, or we don't like this?
They
We seem to get them back, we say we approve, we send them back. Okay.
that's not part of the referral process, no.
Well, this is because usually we prepare, or Mark prepares the ordinances, and we on the planning board discuss them before they go to council.
Right.
But it could happen that council developed a zoning ordinance on its own and then sent it to the planning board, and the planning board would have a serious discussion on it. I remember in the days of Joan Botcha, for instance.
Thank you. I could have done without that reminder. But, no.
It goes back a few years.
Jim, just so you know, it was discussed by council to a degree. It was discussed by the land use committee.
All right, okay. I just didn't know if they ever sent anything back down.
Before it was.
Amen, we like it, or we don't like it. I know we've had controversial ones.
Yeah, we've had situations in the last few
Well, you know that, I
years.
just didn't know what the procedure was.
We've
Okay.
had situations in the last few years where either the council or the land use committee has basically recommended some changes, but
Right.
that wasn't the case this time.
Okay, good, that's all. Just
Yeah, I mean,
I
and
was afraid
procedurally, I just
Councilman
wondered.
Kramer was going to come in and
you know, the
object.
converse happens too, where we've developed an idea or whatever and send it to council, and they have comments or changes or they disagree, and it gets bounced back to us for tweaking as well.
Yeah,
So
yeah.
fortunately, these appear to be
Yeah,
uncontroversial.
those are the obvious ones that you know they're gonna bounce them back. I just wondered if they had any, so they don't. If they don't make a comment, so be it. Okay,
Well,
thanks.
formally, our role is simply to rule on whether the proposed ordinance is in accordance with the master plan. And in this case, I think we also amended the master plan so that the ordinance is in agreement with it. And you remember when we had the ordinance change on the billboards that, we had a lot of people out there yelling at us, and the point was made that our role was only whether it was in accordance with the master plan.
Gotcha. Thank you.
Whereas when they yell at the council backs down.
Okay, so with that explanation, ordinance 3995-12, trap rock, we'll just take that first and have a motion and a second.
Move the approval of the amending code?
Second.
Councilman Chase,
Yes.
Mr. McCourt,
Yes.
Seal MacGyver,
Yes.
Bob Metler,
Yes.
Mr. Pettit.
Yes.
Mr. Stevens.
Yes.
Mr. Thomas.
Yes.
Mr. Alderman. Mr. Onyaka.
Yes.
Chairman Orsini.
Yes. And following that, ordinance 3996-12, Lakeside.
If there's no discussion, I move the ordinance amending the code.
Second.
Councilman Chase,
Yes.
Ms. LaCourt,
Yes.
Ms. MacGyver,
Yes.
Mr. Metler,
Yes.
Mr. Pettit,
Yes.
Mr. Stevens,
Yes.
Mr. Thomas,
Yes.
Mr. Alderman, Mr. Onyaka,
Yes.
Chairman Orsini.
Yes. Okay, so we only have work session new business, which is zoning ordinance amendments, which I assume Mark or Vince will. There's just one other item that we should probably discuss very quickly, which is a letter that I just picked up in my mailbox from Anne Marie, requesting recommendation of planning board members to be appointed to the following: planning board member to the Municipal Wastewater Management Planning Committee for a one-year term. Currently, that's Claude Coble. And planning board member to the Open Space Advisory Board, term concurrent with the planning board term, and currently that's Bob Metler. Since he's not here tonight, I have no problem nominating Marvin to continue in that role. I've heard no objections. And Bob, if you'd be so kind to continue in the open space role. Oh, well, we don't even need nominations. She just wants,
Yeah.
if you're on the planning board, assuming you're on the planning board, you're going to, it's just a matter of volunteering.
Okay, I did put my letter in, but it will be up to the powers that be as to, what happens.
Because you're the mayor's representative?
No,
No, he's a,
But
You're
my
the mayor's
my term ends this year, so it will depend on
Reappointed.
the action of the council.
Okay. Well, at least for now, can you just communicate to Anne Marie that these,
Just saying,
they
yes.
can continue
I'll tell her.
as planned?
Yeah, in the case of Mr. Metler, it would be dependent on his being reappointed to the planning board.
Okay, and that hopefully that should happen. Let's see, yeah.
yeah, we can briefly go through most of the changes except for the one that Mark will talk about at the end, were pretty much cleanup items. We made some changes to the checklist requirements. The most prevalent one is we've been requiring 24 copies of submittals because that's how many we need to get to the board members and to staff, and most people comply with it, but that's our practice. We should have it in the checklist. Then we have some things with submittal to outside agencies. We want to change the use variance requirements to be consistent with the site plan requirements. A lot of the use variance, we waive stuff like traffic reports because we don't need them, but it should be in the checklist, so it gives us the ability to waive it, and we can require it right up front. The changes to the minor site plan requirements that are in the checklist. I remember a couple of years ago, we formally created the technical review committee, which is staff that reviews the minor site plans that meet certain criteria that the planning board does not have to review. We have the old requirements for submittal. 3 or 4 years ago when we did our own little checklist that we've been using and we're requiring. All we're doing is codifying that. Those are the requirements that we've been using instead of the old ones that used to be used for stuff that went to the board, so we're just clarifying that. We have the preservation area marker amendments. Most of those are clarifications to make it clear exactly what's required. The only really substantial change, and it's not a change in policy, because we've always required, is that when people get preservation markers, typically they're the easements made out to the DEP, the DRCC. We've always also made them file it, so the easement is to the township. That's been the policy for 10, 15 years here. It was never codified in the ordinance. Of course, we have a couple attorneys who have questioned that recently and didn't want to do it to us. So this is just codifying what's been in practice for the last 10 or 15 years, so we don't get those questions from attorneys saying, well, we're not legally required, but we'll do it anyway this time.
Is this what we call a conservation easement?
Yes. And typically, when we get a conservation easement, most of them are made out, like I said, to the DRCC or the DEP, and we've also named that we have rights for that. That's what we've always done. I don't know if you did that, Jim, when you were here.
Yeah, we always did it. I mean,
Yeah.
nobody ever questioned it.
Right, and no one ever, well, now we've had a
Well,
couple.
they got nothing else to do,
We got a-
attorneys.
We have a couple who've questioned it, and we've had to say, well, you're right, but do it anyway. So we just want to codify the policy that we've had here. We had a couple definitions. We added a definition for rooming house because we didn't have a definition. And every time we go to court, the judge says to us, well, okay, but you don't have a definition. You really should, so that we can enforce that. The isolated lot, which the zoning board hears 1 or 2 a year, we added a definition and a review, an escrow fee for that, because those typically take a considerable amount of time compared to other applications.
And just real quick, just to clarify, that's when somebody comes in, it's not just a regular hardship variance, it's somebody who wants to put a house on a 10,000 square foot lot in an R20 zone. And it's a little bit more complicated, a little bit more involved in terms of the review. Staff has, more review time associated than if it was just an addition or a deck or something, and just a homeowner coming to the board.
And
Should there be something there about it being a lot not under common ownership with a contiguous lot?
well, that whole thing
Sort of
with,
covered by the lot merger.
yeah, the Lochner and everything else. I don't think that's necessary that we have to repeat all that. And as our attorney will tell you, that in the last 10 years, there are 50 different exceptions to it. They keep making it greater and greater on what isn't, so I don't think it's necessary. We want to do something a little bit generic. Basically, it was for the purpose of, so it was clear what we were going to charge that extra fee for, that we weren't charging because it takes up so much of staff time compared to other things.
I remember when I was on the zoning board, somebody wanting to build on a 40-foot wide lot.
Oh, we had one, we had a 25-foot one that we approved for Mr. Weshnak. Yes.
Some of those have gone, 1 or 2 of those over the years have gone multiple meetings, so
Yeah.
it's expensive to the township to administer those and process those.
We also recommended a series of changes in some of the fees. Some of the fees, like for solar arrays, that we've been charging, but there's nothing in the code. We use it under the other, so it's just crystal clear. The other one that we...
Be sure that there's nothing in state legislation about what we can charge on those. It seems to me Bob Smith had a bill in about
All right, we'll take a look at that to make sure. The other one is the off-street parking. There were a couple things that we did which once again, that we've been using as policy as far as the maximum amount of grade for driveways. Some things like we like to have our driveways perpendicular to the roadway. That we've always tried to have that, but we never had it codified in the ordinance. A couple minor clarifications in it. We have also always asked people to use white striping and blue for the handicapping. Well, we've had a couple in the last year or so asked to use yellow. So we don't approve that, but we want it in the ordinance so it's crystal clear, unless there's some engineering reason, some real reason they can provide waivers. But,
Scaredy cats, little chicken.
yeah.
time. Properly, you use yellow to paint the curb where there is no parking.
Exactly.
But those are the ones, and then the one we mark, who has to spend some time, of course, is the lot shape ordinance.
Before you go, I noticed you've changed all of, now, you won't accept any drawings that are not 24 by 36.
Yes.
What happened to the 36 by 48, which was also a standard engineering sheet? You don't take those anymore.
This ordinance would say that we would accept them at the 24 by 36, yes, instead of the larger ones.
The reason being storage,
The reason being,
printing.
two things. First of all, it's less paper. It's easier for us to store. It's also easier for us to review and bring to the meetings instead of the bigger sheets.
Okay.
It's just a matter of convenience, and talking to most of the engineers who we work with, it's not a big deal because it's another.
It's 6 to 1, half of those.
Yeah, right. It's another
So
standard
paper,
size.
I just wondered why. I thought maybe our computer printouts or something. Or
No, it's also easier for us to scan and everything
Yeah, yeah,
else
right,
in the
okay.
storage, so.
Just curious.
I noticed that in 112-183, you had struck the requirement at least 2 weeks prior to the date of the planning board meeting. Why was that struck? Is it covered somewhere else?
Well, the municipal land use law has very specific guidelines for when you have to hear something and when you receive it. When we're doing the finals, the 2 weeks that's not the date. That was something that someone, I guess, just stuck in there to allow them to do. Typically we do the preliminary and final together. I mean, we don't really deal with that, but that's the 2 weeks is not in the municipal land use law. So we go by the guidelines, the law instead.
Something else is in the municipal land.
Yes, as far as everything, 120 days, 90 days, 40 days, whatever, to 45 days, depending on what application it is, the board's required to render a decision. There's nothing in there about 2 weeks for that. I don't know why that was in there. It was just a matter, we were changing that paragraph anyway, so.
What it does is give you time to give it out to other staff and environmental commission and so forth for review.
Yeah.
And gives them time to review it and get the review back to you.
Yeah, I don't know why it was 2 weeks prior. I mean, there's no way we could possibly, in 2 weeks prior, unless it was, one of our emergent ones like RPM, they need a site plan.
What does it read now? I saw it, I didn't, what does it say now?
2 weeks prior to the date of a planning board
Meeting.
for application of final subdivision, they needed to get stuff to us. Well, the municipal land use law dictates when stuff has to be,
And what does it say about it?
was it 45 days? Is that what the date
So
is
it's a
for
longer
final,
period
I
of
think?
time.
Yeah, I think it's 45, maybe 30, but
It's, okay, so it's longer than 24 days.
longer than 2 weeks.
So, all right, yeah, good.
Okay.
Yeah, okay, all right, okay, fine.
Yeah,
I
and
thought it
typically,
was.
Whether it was or it wasn't, we would still have to go by the MLUL anyways.
Yeah, but I
Well-
just wanted to understand, we're a little concerned because we got guys coming in here demanding meetings when they haven't submitted their plans yet. I mean,
yeah, right.
one of
That's
the
what I
biggest
was thinking.
gripes.
We've never used that, and the only reason why we're changing is because we are changing verbiage in the rest of the paragraph, and I said, we might as well strike that since it's
And
not
the land use
applicable
laws
anyway.
the land use law allows a greater period.
Yes.
So it wouldn't concern, you got time to get everything out. Because I was thinking about what Ted was saying. So-
Is
so-
2 weeks adequate?
No.
No,
So why are we?
We're getting rid of that.
Getting rid of it.
Oh, okay.
We're just getting rid of that, and with no time frame, you go by the municipal land use time frame.
Fine. Great.
Okay. Moving on to lot shape. This is in response to an application that we had a number of months ago. The drawing of that subdivision was in the memo. Basically, the subdivision brought to light a deficiency in our ordinance that we don't have. We have lot area and we have lot frontage, but we really don't have any control on lot depth or any tool to really require that at the end of the day that there is a sufficient building envelope to build a house. And that was illustrated in that subdivision where basically there was going to be a building envelope of between 9 and 15 feet in width. And the lot was actually otherwise technically compliant. So we took a good amount of time to really try to figure out a way to attack this problem, but at the same time try not to create new nonconformities and to avoid unintended consequences. So we've come up with this, and this is not a completely new approach. It's called effective square. And what it does is at the time of, we proposed a provision in the ordinance that at the time of subdivision, when somebody is proposing to create a new 1 or 2 family lot, that at the time when they prepare the drawings, they have to show in each of the lots a square of a certain size, and the size is dependent on the zone that they're in, a square of a certain size that fits within the lot, and that's behind the front yard setback. And in the ordinance, we have the provisions. In the A and the CP zones, it's 250, in the RR5, RR3, MPC, R40, it's 125. Then it goes down as the lots get smaller. And basically, we crafted this so it's not going to be in the bulk table. It's not going to be applied when people apply for zoning permits for house additions. It's not going to come into play then. Again, it's only going to apply when somebody comes in with a subdivision, and it's basically a tool that can be used to make sure that the lots have a minimum reasonable shape so that a house can be, so that the building envelope is of sufficient width and depth for the location of a home without variances. I do have, if the board wants, a sketch of that proposed subdivision with the effective square in that particular zone kind of overlaid, so you could see how that one lot would not be compliant anymore. So yes, sir.
Okay. I just want to be sure of the terminology. In the column you have, which is effective square, you would be talking, say, the R20 would be, by the square would be sort of like 70 by 70.
Yeah.
It wouldn't be like, you couldn't get away with 10 by...
No, in fact, Ted had a comment before the meeting that the language, and just so you know, this is not going to be in the ordinance. This is really just an exercise just to show you how the numbers were derived.
Right.
But Ted made the suggestion that the language in the ordinance, which is this, should probably say 250 on a side or 250 per side.
Right.
So it's clear that it's a square.
Right.
And again, just to make it clear as well, that this does not in any way affect where you can actually place a home. The provisions are completely unchanged with regard to that. The setbacks are the setbacks. Mm-hmm. The coverages are the coverages. This is just to make sure they don't come, somebody doesn't come to us with a hockey-shaped lot where they can place a 9-foot home. Basically would make them push out those lot lines a little bit so they would have a reasonable lot. I think I could say as well that these, and I went over this with Vince and with Carl in engineering as well, because they review these things, so we really wanted to get their input. And one of the things we were talking about during that meeting was, I think these provisions are relatively lenient, actually. We didn't want to, it's not to create the perfect, it's to prevent the absurd. And I think that's kind of the approach that we took here.
Just a question, so that condition that you're showing us that we dealt with, where we tried to talk them into going, I think we tried to talk them into going to 2 lots and making it a reasonable subdivision, but we didn't succeed. But that's, you're not talking, if there's an existing condition, like that existed.
It would not apply.
It would not apply.
No, if they have approval, I don't know if they filed it, but nonetheless, they have a
They had
subdivision
approval
approval.
for 3 lots, right?
Yeah. But
I think
if somebody was
we
to...
basically dared them to try to do that.
Pardon?
To try to fit that. I don't think any of us thought they could actually do it.
I
Maybe
don't-
they can.
I don't
No,
think
I don't think they
I don't
ever
think
will.
they've pursued it, but nonetheless, with this, this would not be a compliant subdivision, and it'd need variances, and I would assume if that the board would deny it, if this was in place.
No, I think it's a good change.
The way you're gonna have this written down, so like we talked about these attorneys that are gonna pick you to death, where are they gonna find this written down anywhere?
It's the language that's in here will go into the zoning ordinance.
Oh, okay, all right,
Yeah.
okay.
It'll be in there. We didn't want to put it in the actual
In the
bulk table.
Oh, I understand, okay.
Yeah, because we don't want,
No, I-
somebody to misinterpret, and then somebody
Understand.
comes in with a house addition, now they're applying this effective square. It's in a
Understand,
separate,
understand.
kind of standalone section.
Okay, so the language will be there, good.
Yep. Any other questions?
Any other questions on any of these changes? So what do you need?
You just need a recommendation for us to send this to council, via the land use to, so they can introduce it, and then it'll be sent back to you like the other two.
Put it in, return receipt in there.
Yeah.
Yeah, okay.
All right, make a motion to recommend that we send it on to council.
Second?
We can do that by affirmation.
All in favor?
Aye.
Opposed? Abstained? Motion carries.
Told you, 8 o'clock, what'd I say?
Okay.
Said if we start on time, 8 o'clock.
As of now, we are or are not going to have our,
I would not expect to have a meeting in 2 weeks unless something crazy comes up. So we don't have any
So
applications or anything
the next scheduled
else.
meeting would be
The reorganization meeting in
first week in January.
January.
January, New Year's Day is Tuesday, so it would be the day after New Year's? That would
I
be
don't,
the second?
I don't think so. I think it's like the week afterwards, right?
Yeah,
Yeah,
particularly because the council intends to have its reorganization meeting on
Right.
Wednesday, the 2nd.
So then our first meeting most likely
it's the
would be
12th.
January 9th.
It is the ninth.
Yeah.
It is the ninth.
And we were told
Ninth,
that it
that's
was
it.
scheduled for the 9th.
Yeah.
The planning
Have we
board.
we've long since passed adopted the calendar
We,
for
we,
2013.
we,
right?
we always adopted January to January.
Oh,
So
we
in
haven't.
January, we'll adopt another
But
calendar.
we've seen it, though. We've approved the concept of when the meetings are. I'm pretty sure.
Not for next year, just till this January.
Oh, okay.
And you can.
Somehow I thought we,
No, we typically at the reorg, you reappoint and we approve the calendar that runs through next January.
all right, so January 9th.
Which is why we do it to January, because we know we don't do it to January.
It's possible. So, well, I remember last year, we didn't have a reorg meeting till February.
Square. And you.
Yes, you're right.
But at any rate, as currently
I do this.
planned, it'll be January 9th.
Doesn't affect the building envelope, so.
So, motion to adjourn.
The lot is.
Second.
Second.